one moment, please. This would be my presentation. Well, it is quite small, no? Or do you see it correctly?
Yes. Yes, we complete. Yes. Mm-hmm.
You see it?
Correct.
See it correctly. Good. Okay. So today, according also to my research plan, I would like to have a presentation on the evaluation of the operational experience of the Supreme Administrative Court in Slovakia. And it is quite an interesting thing, as I was looking through the presentations today, and I saw that also Kitti has a presentation on the electoral issues of the Hungarian Administrative Court, and I also prepared a case study from the Slovak experience, because this changed quite a lot with the institutionalization of the Supreme Administrative Court in Slovakia, as the electoral cases and electoral issues were mainly or decided by the Constitutional Court before, and there were several issues which tackled the question of efficiency and especially the speed and effectiveness of such decisions. While these decisions are quite important from this point of view, I usually, as always, I did prepare a little presentation on this matter with a few slides which I would like to comment and show you. If we are talking about the efficiency of the judiciary procedure or administrative judiciary, we should consider one very important fact, I would say, that is that while the administrative courts and the proceedings before administrative courts do not count as administrative procedures in stricto sensu, it is very, very important that the administrative procedures, the judiciary procedures, are a little bit similar to the administrative procedures, because in principle they could be accepted or could be viewed as an extension of the basic administrative procedure. So the judicial review of administrative acts or administrative actions is therefore has to show up quite a little bit of similarity. So it has to balance between the classical judicial procedures and the administrative procedures. Why I'm saying this? Because if we are looking at the administrative procedures or the efficiency of the administrative procedures, we can see several principles which deals with the efficiency or effectivity of administrative procedures, and very, very important part of this is, of course, the speed, the quickness of the procedures, and the low costs of the procedures for the clients. Of course, there are very important other principles, as the principle of legality, which is the basis of all administrative procedures, which states that the authorities shall comply with and enforce the provisions of the law. So this is the basic principle of all administrative procedures, that they should be legal, and this puts also quite a lot of obligations on the authorities as well, but not only on the authorities but also on the client's rights. This is the second principle of the client's rights, which is quite a wide range of rights. However, the relation of the authority and the client is very important in this matter, as in administrative procedures, the authority is also interested in the outcome of the proceeding, also together with the principle of legality, and the authority should also consider the public purpose of the administrative procedures. So the authority has to inform the client, has to care a little bit more about the client than in a classic court procedure it is customary. And also it is complemented by the principle of officiality in most states across Europe. It is the same in Hungary, it is the same in Slovakia, in the Czech Republic, and I suppose it is the same in Poland also, that the administrative authority shall act actively to help finish the administrative procedure, also to help the evidence procedure. The administrative authority shall be very, very active through the whole administrative procedure in general. And there also in the Hungarian, but not only in the Hungarian regulation, it is basically stated that the administrative procedure should be quick compared to other procedural type, and should cover or should be covered by low costs, which is mainly not only from the client's point of view, but also from the authorities' points of view. But the speed is usually enforced by terms, by obligatory terms, usually 30 days, or in the Hungarian regulation, the basic administrative procedure should be not longer than 80 days. So there are different regulations, but basically we can say that usually about 30 or 60 days, a classic administrative procedure should be done, and the decision should be made by the authority, by the administrative authorities. So these are the main questions which I want to get on, or which I would like to think about or talk about according to judicial review, because, as I told it in the beginning, while judicial review of administrative acts or administrative actions in general is not a administrative or not a special type of administrative procedure, it can be seen as a continuation of the administrative procedure. And there are some interests or some principles which a little bit, not in a great degree, but in a little bit can be contradictory. The first is the legality, officiality, and the client's rights. As in the judicial review or the functioning of the courts, the judge is usually someone who is not interested in the outcome of the case on hand. Well, he is, or the judge, or he or she is, of course, interested to finish it legally and right, if I may say it so. But the principle of officiality is applied in the court proceedings only very, very extraordinarily, and it's only in special cases. And also the courts or the judges during the judicial review of these proceedings, the court is not the court is interested in the client's rights, but he will not carry out so much care than the administrative authority has an obligation. The second is the quickness and the cost effectiveness versus the independence of the judges. As usually the judicial review or the court proceedings are not time limited, so it is rather an extraordinary thing that there is some limitation on the length of the procedure. And also this means or this tackles the question of cost effectiveness also, because usually administrative or court procedures are more costly than administrative procedures, and in some court procedures there is also an obligatory use of an attorney. So a balance of interest should be achieved, in my opinion, to make the judicial review of administrative acts a little bit similar to administrative procedures, as they follow the same purpose, namely the pursuit of public interest. If we go back a little bit to the jurisdiction of the Supreme Administrative Court in Slovakia, and we are taking a little bit of a turn to the main course of my presentation, we can see that basically this is the overview of the jurisdiction of the Supreme Administrative Court in Slovakia. There are cassation appeals, the administrative actions. The judge decides on electoral cases, also in the cases or issues of political parties, in competence cases when there is a dispute between administrative authorities and also disciplinary cases in case of judges, which is quite an interesting part, is the elections part, or the electoral jurisdiction of the Supreme Administrative Court in Slovakia, as it is this part, or exactly this part of the administrative judiciary where public interest should be represented in a very extensive way. If we look at the case study at our hand, there is a decision, or there was a decision from 2008 of the Slovak Constitutional Court about the municipal elections of Dunajská Streda, which were held in 2006 December. So you can see there are two or three things which I want to point out. The first thing is that in this time, around the years 2008 and 2006, the Constitutional Court was the highest court, or the relevant court for electoral procedures, and also in the case of municipal elections in Slovakia. This brought with itself also some problems, as the Constitutional Court is not a classical court, or not a classical court in such sense that the evidence procedure is different usually at the Constitutional Court. So the Constitutional Court is or was at the time not really prepared for this type of cases. The second thing is what you can see, that the decision was from November 2008, while the elections were in 2006 December. That means that it took the Constitutional Court 2 years to decide on this matter. It is half of the time limit for the major. That is the general election term in Slovakia is 4 years. So it took half of this time, 2 years, to decide on this matter. Of course, this is an extreme example, because usually the Constitutional Court ended all cases in 6 or 8 months, but that was also quite a long time. But if we consider this extreme case, that means that there is a 2-year period where the legal certainty of the elected major was questioned. And of course, if we talk about the costs, there is a mandatory representation before the Constitutional Court, so it skyrocketed the costs of representation for both parties, the plaintiff and the defendant also. Well, the ruling of the Constitutional Court was that the result of the election is cancelled ex tunc. So from the beginning, that means that the elector or the elections were null and void, were declared null and void, as the major was not. So this created a situation that, like, the major would not be appointed. But this raises not only a question of legal certainty in that way, that the decision took 2 years, and that also created some political tension in the municipality. But it creates a legal certainty in that way that if the elections were cancelled ex tunc, that means they are null and void from the beginning. That means that the major was not elected. But what happens to the contracts he signed? What happens to the municipal ordinances he signed, or the permits, or the decisions of the municipality? Are they null and void also? Because according to this logic, if the elections were null and void, that means that the major was not appointed. That means he was not statutory representative of the municipality at the time he signed all these documents. So this created quite a lot of questions. This case also, but usually also the electoral jurisdiction of the Constitutional Court in Slovakia. This was, if I may address it in a stricter way, this was not a very well or a very effective case of electoral judiciary or electoral control, as usually in electoral cases, the decisions should be definite and should be made quick to to assure that there is a legal certainty of the results of the elections. How is it changed at the current level or current state? It has changed quite a lot because it is at the moment a special procedure at the Supreme Administrative Court of Slovakia. The basics of this procedure, you can see here that who can start such a procedure, who has the active legitimation, in which cases and against whom, if there is a time limit for the decision, and what decision can the Supreme Administrative Court make in the case of electoral things. So the general rule is that the plaintiff may bring an action for a declaration that the contested election is unconstitutional or illegal, and thereby ensuring free competition of political forces. So basically, the plaintiff or the main reason is that the elections were not constitutional or they were against the law. This is also quite an interesting question in this matter, that the Supreme Administrative Court in this case can decide in the constitutionality of an election, while it was basically in a jurisdiction of the Constitutional Court. But this is from a theoretical point of view. The regulation is like it is. The applicant can be, or the plaintiff can be, any candidate who received at least 10% of the valid votes. It can be a political party or a political movement, or 10% of the eligible voters of the electoral district concerned. So there is a regulation, or the regulation brings in something like an actio popularis, that 10% of the voters can also go against the result of the election. That is quite a new thing in the Slovak regulation. So not only the candidate who lost, not only a political party, but also the voters themselves can challenge in this procedure the legality and the constitutionality of an elections. Against whom is the next important question. It can be applied against the political party, of course, or an elected independent candidate, or the mayor of the municipality. Usually, if it is the case, what is important, that is that the action must be brought within 10 days from the date of the announcement of the result of the election. So there is a 10 days limit for the action. The 10 days limit for the persons who have active legitimation to file this motion against the at the court. And as I told, the constitutionality and the legality of the elections can be challenged both. The very important question is the time for decision, as the new regulation for the Supreme Administrative Court states fixed dates. They have to decide on this matter. That means that the Administrative Court shall decide on the action within 30 days from the date of the receipt of the application. And there is a special rule that in particularly complex cases within 60 days from the date of the receipt of the application. But the general rule is 30 days, and also the court can extend it to 60 days in complex cases, but that is left to the consideration of the court. But there is a time limit, which is quite important, that these things should be decided quick. These decisions should be very definite in a short period of time. The next important thing is that this decision on the result of the elections is final of the court, so it cannot be challenged once more or on other judicial forums. The Administrative Court examines the application, and if the Administrative Court finds that the action is well founded, the judgment can take three forms. The Supreme Administrative Court can declare the election null and void. That means non-existent, meaning new elections should be made. New elections should be reinstated. It can annul the contested result of the election. That means that a special type, but because the distinction between the election null and void and the annul the contested result of the election is the difference that if the administrative court declares the election null and void, that means that not only the major but also the city council elections are resetted and declared null and void. The annulling of the contested result of the election means only a partial question dealing the elections, for instance, one member of the city council, two members of the city council, or one electoral district, or only the major. So it can be made. And the third thing is very, very interesting, that it can annul the decision of the electoral commission, the Central Electoral Commission, and declare the person duly elected. So in this matter, the administrative court has the jurisdiction to change the decision of the Central Electoral Commission and appoint someone and declare that another person was voted for or elected as mayor or as city council in case of municipalities. There is, however, one big question, and that goes for the evidence procedure. And I wrote it here that it has to be seen as no such procedures were implemented at the Supreme Administrative Court in Slovakia at current time, as there were no municipal elections from the creation of the Supreme Administrative Court in the last year and a half. And it is extremely important from the upcoming days, as municipal elections are coming up this Sunday in Slovakia, so in 2 days, if I may say so. So I think that the upcoming month will be very, very interesting from the effectivity from this point of view, how will exercise the Supreme Administrative Court these new rules, and what will be the result of this short procedure, if the Supreme Administrative Court can handle or will be able to handle all cases which will come in from all the 3,000 municipalities, or can come in potentially from the 3,000 municipalities in Slovakia. It is yet to be seen, and I think that we are very eager, or I'm very eager to see it. How will this affect the work of the court? Thank you for your attention, and that would be my presentation for today.
Thank you very much. And as the agenda is following, now I would like to please Kitti Pollák to take the floor.
Need 1 minute to share my PPT. I am trying my best.
Yes.
And I hope I'm sharing. I hope you see my PPT right now.
Yes, now we can.
Sorry, I have the feeling that something is okay. So, do you see?
And now, okay, and at this moment we can see your presentation, but you know, the minute before it was just your screen. Oh,
yes, this is perfect. Yeah.
Okay. Yeah. Okay, I'm very happy. So good afternoon, all of you. In my last presentation, I was always examining in detail the legal regulation of administrative court procedures and the questions raised regarding the rules of Hungarian administrative court procedures with a comparative analysis to the Polish regulation. In today's presentation, I would like to present special dilemmas regarding a special judicial review procedure, regarding the judicial review procedure in electoral cases, as our open scientific seminar is titled as Special Aspects of Administrative Justice. So first of all, I would like to note that the fundamental law of Hungary states that the source of the public power shall be the people, and the power shall be exercised by the people through the elected representatives, or in exceptional cases directly. In my PPT, you can see the different types of elections in Hungary and in Poland. I would like to only note three things regarding the PPT. First of all, the biggest difference regarding the elections is that in the presidential elections in Hungary, contrary to Poland, is not directly elected. The Hungarian National Assembly elects the President of the Republic. Secondly, it's very actual from news from the last weeks, months, regarding local government elections in Hungary and local elections regarding Poland, that in Hungary, the Hungarian parliament voted that from now, the European Parliament elections and the municipal elections will be held at the same time, so in 2024, spring 2024. Meanwhile, in Poland, regarding the local elections, as I saw in the news in the last weeks, there were lots of questions regarding when it will take place in autumn 2023 or in spring 2024. Thirdly, I would also like to note that regarding the different elections in Hungary, there are special rules codified in different acts. Meanwhile, there is the general rules on election procedures, which can be found in the Act 36 of 2013 on the election procedures, on all election procedures. I shall also note that the general rules of administrative procedures, which can be found in another act titled as the Code of General Administrative Procedures, cannot be used in election procedures. Regarding the legal remedy possibilities in electoral cases, we shall note that there are three legal remedy possibilities used in electoral cases. There is the objection, the appeal, and the judicial review possibility. Objections may be submitted by voters recorded in the Central Electoral Register, candidates, nominating organizations, and natural and legal persons and organizations without legal personality affected by the case, referring to the branch of the laws of the elections, of the fundamental principles of the elections, or regarding a branch of the law of the election procedure itself. Meanwhile, appeals can be submitted by natural and legal persons and organizations within the without legal personality affected by the case, challenging a first instance resolution by the Election Commission. So against the first instance resolution of the Election Commission, an appeal can be launched. But what happens if it is a second instance electoral commission who made the resolution, or the resolution is made by the National Election Commission? In this case, there is no possibility for appeal, but there is the possibility for judicial review. All cases, so if there is in general, in these cases, judicial review is the possible tool for legal remedy, and in these cases, the highest court of Hungary, the Curia, decides on the cases. Regarding judicial review, I would like to note that there is no further legal remedy possibility regarding the decisions of the court. What I would also like to note that there are special legal remedy procedures like the legal remedy against electoral register, which also I would like to state that there is a very, very complex regulation regarding the court procedure in administrative cases. So what I would like to also know that statistically, the last elections was the National Assembly elections in Hungary in the spring 2022, and basically there were less than 100 cases in front of the Curia. the case allocation in the Korea regarding electoral cases is very automatic. So the case allocation is determined by the order of the arrival of the case, taking into account that every 2 cases will be assigned to one judicial council, and then the next 2 cases in the order of the arrival of the case will be assigned to the next judicial council, and so on. So there is a very complex regulation regarding court procedures. The general rules regarding the judicial review procedures, which is determined in the Act on Election Procedure, shall be used in the special legal remedy procedures. But the Act on Election Procedures states that the Code on Administrative Court Procedures shall be used, and the Code of Administrative Court Procedures declares that in the provisions in several cases when the Code of Administrative Court Procedure expressly refers to the application of the Code of Civil Court Procedure, the Code of Civil Court Procedure shall be used. So you see, it's a very complex regulation, because you should examine in the same time, if it's a special legal remedy procedure, you should use the general rules regarding judicial review procedures at the Act on Election Procedures. You should use in the same time the Code on Administrative Court Procedures, and in special cases, when it is referred in the Code of Administrative Court Procedures, you should also use the Code of Civil Court Procedures. So it's a very complex regulation. Therefore, with this complexity, there are several dilemmas regarding the judicial review procedures in electoral cases, and I just wish to present 3 questions regarding these cases. First of all, shall all court decisions of electoral cases be published? So regarding the Korea's decisions in electoral cases, it is published in the Korea's homepage, and it was also published in an open access collection of court decisions. So if the Korea decides, and in most cases, most electoral cases, the Korea decides, the Korea's decision is published both in the Korea's homepage and both in the open access collection of the court decisions. As I already mentioned, that there are special legal remedy procedures, and one of the special legal remedy procedure is the legal remedy regarding electoral register. If it's the case of electoral register, an appeal can be challenge a decision of a local election office regarding the central electoral register. If in this case the local election office, so the head of the local election office, grants the appeal, he or she shall modify the electoral register. But if the head of the local election office does not grant the appeal, so he does not modify the electoral register, he shall refer the appeal to the regional court in Hungary. And then in this case, the regional court will decide on the appeal. And regarding the opinion of the Korea, which this opinion is dated to 2021, the Korea expressed that these electoral disputes related to electoral register are specific administrative court procedures. And in my point of view, that all decisions made by the regional court on merits of this case shall be published and shall be published in the collection of court decisions because they met the criteria declared in the Act, how and which kind of decisions shall be published in the collection of court decisions. So this is the first dilemma which I wanted to present. The second dilemma is regarding suspension of the administrative court procedures in electoral case. This is a very interesting question because administrative court procedures in electoral cases are basically 3 days procedures, which means that the courier shall decide in most of the cases in general in 3 days from the receipt of the judicial review So this 3 days is very, very short period for making the final decision. So the question is, can in any case the court suspend this procedure in electoral cases? There is not a prohibition regarding the possibility to suspend the court procedure, and it's not regulated in detail, this prohibition or possibility, nor in the Act on Electoral Procedure, nor in the Code of Administrative Court Procedure. Meanwhile, in the Code of Administrative Court Procedure, there is the reference to the Code of Civil Court Procedures regarding the suspension of the court procedures. Meanwhile, I think this regulation regarding the suspension possibility in electoral court cases could be useful, but need to be specified in more. I would like to give an example. For example, there are 2 very similar cases. In the first case, the courier have already decided on merits on the case. Against this courier's decision, there is the possibility to start to launch a constitutional complaint, and launching this constitutional complaint, it's a 3-day period. You have the possibility to start to launch a constitutional complaint. In this case, the constitutional complaint on the constitutional complaint, the Constitutional Court of Hungary decides on it. And the problem is that the Constitutional Court first have a 3 working day possibility to examine this constitutional complaint, and if this constitutional complaint is admitted by the Constitutional Court, there is 3 more working days to decide on this constitutional complaint, which was launched against the court decision regarding this electoral case. The problem is that it's more than a week-long period, and in this week there can be similar cases or with similar legal questions launched in front of the courier. And in this case, due to the limited precedent system in Hungary, the courier shall decide as the same way as in what it was decided in the first case, which is in front of now, which case is in front of now, meanwhile in front of the Constitutional Court. So I think in this case, for example, it would be also useful to suspend the newly started procedure in front of the courier until the receipt of the decision of the Constitutional Court. But this suspension, I think, shall be more codified and more regulated, more in detail regulated in the Act on Electoral Procedures or in the Code of Administrative Court Procedure. The third dilemma is regarding the uniformity of law, how to be ensured in electoral cases. I would like to note that in Hungary, the fundamental law of Hungary states that the Curia shall ensure the uniformity of the application of the law by the courts and shall make uniformity decisions which are binding the court. There are several tools regarding ensuring the uniformity of law. I would like to only name one tool which can be really in question regarding electoral cases, and this tool is the uniformity procedure. The uniformity procedure shall be started in order to ensure the uniform jurisprudence, or if a judicial council of the Curia wishes to deviate from a decision published in the collection of the court decisions of the Curia. In this case, in the second case, this judicial council can launch a motion for plenary ruling and can ask for a uniformity procedure to be started. So I should also know that during the elections of the National Assembly in 2022, this kind of uniformity procedure was not launched, but I think it can be some cases useful if one judicial council of the Curia wishes to deviate from a decision published in the collection of the Court of Decisions of the Curia in an electoral case. So I think it can be used. It wasn't used before, but the problem is very general, that there is this 3-day time limit for making a decision in an electoral cases. But generally, the uniformity procedures are very long, so it can take several months when there is a decision in a uniformity procedure. Therefore, I believe that there shall be a more specified regulation regarding this uniformity procedure in case of electoral cases too. So I think new regulation is needed, more specified regulation is needed regarding this procedure too. So today's presentation, I only highlighted some of the dilemmas regarding judicial review procedures regarding electoral cases. And in my next presentation, I will also focus and present further questions related to judicial review procedures of electoral cases. And thank you very much for your attention. And if you have any questions, I would be happy to answer it.
I think there are no questions.
Okay, thank you.
Yep. So thank you very, very much. And now I would like to ask to take the floor our Polish colleagues. So Professor Przemysław Ostojski, the floor is yours.
Thank you so much. Can you hear me well?
Yes.
So hello, everyone. I'm delighted to be speaking with you today, and I appreciate you being here. And in this presentation, I'm going to walk you through some of the basic standards of judicial review according to the case law of the Court of Competition and Consumer Protection in Warsaw. Since I only have 15 or 20 minutes to comment on these issues, I'm going to keep these things brief. And this talk will be divided into 6 sections. That means, first of all, I'm going to talk about subject matter of review of this court. Secondly, about procedural scheme and jurisdiction of this court. Thirdly, procedural doubts around the model of the judicial review. Fourth, court's assessment of authority compliance with procedural rules. Fifth, ab initio fact findings. And sixth, about interpretation and application of substantive law. And let's start at the very beginning. That means about the subject matter of review of the Competition and Consumer Protection Court. It's quite important that, according to the Article 81st of the Act on Competition and Consumer Protection, this provision sets forth the general rules for appealing decision issued by the President of the Office for Competition and Consumer Protection in course of proceedings before him. And the subject of these appeals can be a decision declaring practices to be restrictive of competition, in which the President of the Office orders the abandonment of practices that violate the prohibitions, of course, if the practice has not been discontinued by the time the decision is issued. And what is very characteristic in competition cases, the President of the Office can order appropriate measures in the decisions, consisting in particular of granting licenses of intellectual property rights on non-discriminatory terms, or allowing access to certain infrastructure on non-discriminatory terms, or amending a contract, or providing other entities with the supply of certain products or the provision of certain services on non-discriminatory terms. And finally, what is also a characteristic feature of the subjects of these decisions, they can impose a fine on entrepreneurs on no more than 10% of the overall turnover. And the subject matter of this review can be a proof itself that they are simply administrative law cases. The competition law cases in Poland and generally in the EU are the administrative law cases. And what about the jurisdiction of the mentioned court? It is important that as I mentioned, the subject matter are the administrative decisions. And before the appeal will be lodged into the Court of Competition and Consumer Protection, the decision should be final. And the procedure before the President of the administrative authority is called in literature as the pre-trial or pre-jurisdictional proceedings. And the final characteristic of this decision is the mandatory prerequisite to the court proceedings. And at the same time, this procedure is called in both literature and in the case law as the so-called hybrid proceedings. Why? Because the court is not a higher authority in an administrative process. The relevant provisions or the provisions of the Code of Civil Procedure, and at the same time, appeals to the court have traditionally been considered as an equivalent to lawsuits in general civil proceedings. So we have, on the one hand, the administrative decision, they are the subject of judicial review, and on the other hand, we have the hybrid proceedings with provision of the Code of Civil Procedure. And the subject matter of cases is, as I mentioned, administrative legal nature, of an administrative legal nature, but jurisdiction is in civil court. And jurisdiction of administrative court in competition protection matters is precluded. The procedure after the lodging the appeal to the Court of Competition Protection is the first instance court proceedings under the general principles of adversarial proceedings. Of course, when it comes to the first instance judgment of this court, parties can lodge the appeal to the Court of Appeals in Warsaw, and when the appropriate prerequisites are met, they may also file a cassation appeal to the Supreme Court. And now let's turn to the procedural doubts around the model of judicial review. In terms of the method of judicial review and at the same time procedure questions, there are two main views on this subject in the doctrine and jurisprudence. The first view provides that since the court is examining the case anew and is deciding the case on its merits, it should conduct factual and legal findings independently of the findings made by the president of the office. This scheme of reasoning rejected the admissibility of examining the antitrust authority's error in factual findings, what is crucial, and in this regard rejected also the possibility of examining violation of procedural law. This point of view was presented in many cases in 2012 rulings of the Court of First Instance and Warsaw Court of Appeals. But there exists also the second point of view presented first of all in the Supreme Court judgment from 1990. And according to this point of view, Court of Competition Protection has the power to remedy the defects of the competition authority's decision. And since the Act stipulates that an appeal to the court is against the decision of the president of the office, there should be no doubt that in judicial proceedings, the court exercised judicial review over the legality, reasonableness, and purposelessness of the decision issued by the office. And according to this point of view, judicial review of the Court of the Competition Protection exercised is in fact very similar to the judicial review of administrative actions carried out by the administrative courts. And we can find also one very well-known in Polish literature and judiciary opinion to the judgment of the 8th March 2012, that is the attempt to reconcile both of the above mentioned positions. And according to this reconciling the judgment, the Court of the Competition Protection recognizes the appeal as a court of first instance, and as we know, the court performs a first instance review of the decision of the president of the office, and this is why the competition protection proceedings are hybrid in nature, and they combine the elements of first instance judicial proceedings with certain elements of second instance review of an administrative decision, what is characteristic especially for administrative courts. And this is also because the judgment of the court resolves the legal existence of the appealed decision, eliminated it from legal circulation, or maintaining it in regulation, its legal circulation in its previous or amended form. And now I would like to indicate shortly on the court's assessments of office's compliance with procedural rules. And we have here three main judgments of the Polish Supreme Court. They indicate on the entrepreneur's right to defense and the necessity to respect the institutional and procedural guarantees of individual rights provided both in substantive and procedural law. And very briefly also about the ab initio fact findings of the Court of the Competition Protection. Generally, there are no obstacles to use by the court a record gathered in the proceedings before the competition authority. Nonetheless, the court should make its own findings of facts in the first instance procedure. And this fact was indicated also, stressed in the case of the court Polska Presse versus the president of the competition office, where the Warsaw Court of Appeals overturned the court's judgment and remanded the case back to this court, concluding that the court of first instance, when establishing the facts, limited itself to stating that the fact establishing the decision of the president of the office in question were uncontested. And the Court of Appeals noted that the district court should review the case from the beginning, consider the totality of the evidence, make its own findings, and cite the evidence on which it relied, and discuss the opposing evidence as well. And there is a question whether the court should duplicate the evidentiary steps previously carried out by the president of the office. Because in practice, many times the court bases its findings on the material gathered in the case by the competition authority. And there is also a question whether the court may conduct evidence proceedings ex officio. And one of the example for this question is the ruling of the Polish Supreme Court from 2010, where court formulated the principle that in cases involving appeals against decision of the market regulator imposing fines, under certain circumstances, it may be necessary to admit evidence by the court, such as the explanations of an entrepreneur who was not heard in the competition proceedings, even without the party's evidentiary request. That means Supreme Court formulated a principle that there are allowed evidences admitted by the court ex officio. And the main reasoning of this principle is that when the court doesn't conduct certain evidence, the court may expose itself to the charge of incomplete clarification of the fact of the case. And finally, I would like to indicate only the in two sentences the issue of interpretation and application of substantive law. And I would like to indicate that because the Court of the Competition Protection is the first instance court and should conduct the case de novo, this is the court of facts in practice. It's not the court of law, as for example, administrative courts. And, in practice, any disputes at the law generally arise in proceedings before the appellate court, the Warsaw Court of Appeals. And if the case is allowed to be heard by Supreme Court, also before this court. And if the court concluded that the Office of Competition Protection had misinterpreted the norms of substantive law, established facts, it should change the decision of the antitrust authority forming legal relation in the area of competition law on its own. Well, and that concludes my presentation today. That's just about all I've got time for today, and I hope you have learned something about the standards of judicial review of this special court, specialized court in District Court of Warsaw. And I'm looking forward to talking with you and listening to you next time. Thank you very much.
Thank you very much, Professor. And now I would like to ask Professor Agata Kosieradzka-Federczyk to take the floor.
Okay. Yeah. Good afternoon once again. I will try to upload my presentation. Okay. I remember that last time I've got difficulties, and actually I prepared before email just in case Agata to you, and could I send my presentation immediately?
Yes, of course,
because
no problem.
yeah, okay, so I've already done, because I think that I will need more time, and if I ask you for a favor, it will be just faster.
Yes, of course.
Okay.
Okay, I'm downloading it, so just one more second. And I think
That
it's we have some issues with connection. I think that Professor has she's with us.
I think that now we can hear. And
Yes, we can.
And let's start. My issue, so Tutela cautelare, as I said before, so temporary protection that might be given before administrative court or even before at the stage of administrative procedure when the complaint is filed to administrative court. So can you switch to the first slide? So
use this
yeah, can I do that?
Can you switch the slide?
Yes.
Oh,
So yes, everything is okay. So as Gábor Hulkó said at the beginning, the procedure before administrative court is not limited in time. Sometimes happens that the act provides that regulation, but usually it's not limited. It means that it may take half a year or even 1 year or even more to end that procedure in front of administrative court. And during that time might happen a lot of things. And it may happen that the complainant is not more interested in the solution of the case because it lasts too long. And it is one observation, and the main issue is that what kind of administrative remedies we can employ to make that protection before administrative court is full, that the procedure before administrative court is fair. And the answer is that we can employ temporary protection. And this protection is intended to ensure that until the final determination of the case by the administrative court, the complainant is not adversely affected by the implementation of the challenged act or action. What does it mean? That interim protection in administrative court proceedings is an administrative law institution for the protection of the subjective rights of the parties to the administrative relationship that is subject of an appeal to the provincial administrative court. The granting of temporary protection, which is the suspension of enforcement of the contested act or measure, is of an exceptional nature and must therefore be interpreted accordingly. As can you see, the legal framework is quite simply. We have one article of the law on proceedings before administrative courts, and as a rule is that filing the complaint to the administrative court does not suspend the execution of an action or act complained of. And what next? Court or administrative authority may grant temporary protection after complaints have been brought before administrative court. So here you can see that the court or an administrative authority in fact differs, because according to Polish law, the file is brought to the court, but first it is sent to administrative authority, and administrative authority resent the file to the court. So first, administrative authority has the opportunity to issue temporary protection, and if not, the compliant can ask the court to give that protection. So interim protection against a potentially unlawful act or administrative activity or even a local law which results from its function must be granted as soon as possible and at earlier stages of administrative court proceedings. before its conclusion and the definitive resolution of the issue of the legality of the contested local act, administrative act of any kind of administrative activity. The function of interim protection against any form of public administration action, including a normative act, is to prevent the harmful or irreversible effects that may arise from that form, so should it turn out to be unlawful. The granting of such an application and thus extending so-called interim protection to the applicant is only possible if there is a danger of significant substantial damage or effects difficult to reverse. Both of that issue are important. And the onus is on the applicant to make this plausible. So he or she must state the specific circumstances justifying the suspension of the enforcement of the contested decision. And what does it mean that the danger is substantial, that there is a substantial damage, the danger of substantial damage. So it is assumed that it happens when it's one that will not be compensated by the subsequent return of the consideration rendered or its enforcement, nor it will be possible to restore the thing to its original state. On the other hand, effects which are difficult to reverse are such legal or factual effects which, once they have occurred, cause a significant or permanent change in reality, and the return to the previous state of affairs may take place after a longer period of time or with a relatively large expenditure of effort and resources. Thus, the prerequisites conditioning the suspension of the execution of an act are not any effects of any damage, but damage and qualified effects like exceeding the normal consequences connected with the execution of the act. And what about object of interim protection? This is quite interesting field. Now I want to say that they are acts or actions that, as we say in literature, in judgments that are enforceable and require enforcement. And those both elements are important. So it is not any kind of administrative act or any kind of administrative activity, but this one that is enforceable or require enforcement. And now I would like to say that the concept of enforcement of an administrative act should be understood as causing a voluntary or by way of enforcement a state of affairs that is consistent with the decision contained in the act. The object of an execution of an administrative act is therefore any behavior of the subject obliged to execute it, the addressee of an act consisting inter alia in acting or not acting in a specific manner. When we are talking about tutela cautelare, so a kind of summary, who decides on tutela cautelare? So administrative authority before sending the case to the court, and when the case has been already sent, it is the issue of the court. And when administrative authority, and at this stage on request, or administration can act as official. When the case is sent to the court can grant temporary protection, but as you can see, the applicant's request is required. And what is the issue of tutela cautelare? So it is the order to suspension of the enforcement in whole, in a part of the act or action. And when we are talking about grounds of deciding on tutela cautelare, we have to analyze the type of the act or action of the administration that it is complaint of. As I said before, usually we are talking of substantial damage that is difficult to reverse, but it is interpreted in different way when we are talking about decision, so individual act, and in different way when we are talking about local law. And in that case, we can think about local law that it is already a part of the law, so it is in vigor. And the second possibility is that that the local law is not already part of the law, so it is issued but is not entered into force. And I would like to think about any possibilities, and I would like to analyze the consequences of the Polish regulation. And of course, I would like to focus on exemptions. As I said before, the rule is that the bringing case to the administrative court does not suspend the execution. It is rule, and we have tutela cautelare as an exemption, but it is not as exemption as let's say exemption, because when we are talking about interim protection, it is the interest of international institutions like Council of Europe. And in my research, I would like to focus on some acts of the Council of Europe, like recommendation on interim judicial protection, which refers to an administrative act, and the recommendation of the judicial review of administrative acts. So just an overall observation that it should be pointed out that in accordance with the above mentioned recommendations, the possibility of granting interim protection in the event of administrative act being challenged before administrative court constitutes the minimum universal protection which must be provided. So maybe it is exemption, but it is exemption that must be provided by the member states of the Council of Europe. At the same time, the recommendation on interim judicial protection leaves to the addressees a wide range of possibilities for its implementation. The measures and form of protection defined by the Council of Europe does not preclude the broader design of the above institution. So these recommendations must be treated as a proposal for a uniform format of temporary protection of for member states. So why it is important? Because, as I said before, the case must be decided at the time when it is no longer possible to actually realize the entitlement, precisely because of the time it took the court to reach judgment. So it is based on the need to ensure efficiency of the court administrative process so that a party does not suffer the adverse consequences of the annulment by the court of the contested act or action. And it guaranteeing individual legal protection before the administrative court and thus provide procedural solution to the party so that the judicial and administrative process can be considered as a fair process. And there are some questions when we are thinking about Polish law and we are thinking about international standards. I would like to do some research what the standard for judicial protection derive from international regulations and how are the standards applied in Polish law. And the most important question, issue maybe, of course, refers to the recommendations for changes to Polish law. And it would therefore appear that having regard to the function of interim protection administrative court proceedings, which aims to preventing the occurrence of harmful or irreversible effects of a form of administrative action, which may turn out to be unlawful, the formula of suspension of implementation of a form of administrative action can and should be understood broadly as a suspension of the validity of a form of administrative action and the effects that have results from or may result from that action. So maybe it is exemption from the basic rule, but this exemption is very important to have a fair trial in front of the administrative court. And I hope that next time I can present to you findings of my research. Today, thank you for your attention. If you have any questions, please, I'm at your disposition.
Thank you very, very much. I think there is no questions at all. So now I would like to go to the last but not least, of course, Mateusz Pszczyński. The floor is yours.
Mogę prosić o uruchomienie prezentacji? O, dobrze.
Czy tę prezentację pan wgrywał tutaj?
Nie, ale się, że tak powiem, otworzyło dostęp. Mam dostęp teraz.
Aha, jasne, to proszę działać.
A to chyba mam dostęp do waszych. To nie to. Jeszcze raz. Do you see my PPT?
Yes, we do.
Yes.
Okay, thank you. Taking of evidence and online hearing. I continue the theme about proceeding online or electronic before administrative court in Poland. Now we have some limitation of online hearings, and it is connected also with the evidence, electronic evidence. As a rule, the judicial proceedings in the article of in the Polish court administrative is connected with the model of administrative proceedings, that the Polish administrative court is a court of law, not to the facts, and this determined the procedure. As a rule, the judicial proceeding in the light of Article 106 are a supplementary nature. This result from adoption of a model of adjudication in which the court review the legality of the challenged administrative decision on the basis of the administrative case file. It considers not only on the legal state in force on the day the decision was issued, but also the factual status on the basis on the collected evidence collected by the administrative authority. The essence of judicial review is to assess whether the public administration body has gathered complete evidence to establish all legally relevant circumstances. The court also examines whether the evidence has been properly assessed by the body in accordance with the procedural rules. But the essence of thus there are the existing evidence in the form of a document shall be assessed before the administrative court. Exceptionally, the court may conduct supplementary proceedings upon request or ex officio, provided that they relate to significant doubts relating to the law and not to the facts. Accordingly, supplementary proceedings, documentary evidence that was not admitted or assessed in the administrative proceedings shall be admissible. Supplementary proceedings may not serve to establish facts toward a substantive decision of the case. The evidentiary proceedings framework before the administrative courts result in the fact that in the actual situation of online hearing, procedural steps will be highly hampered, if it impossible. Indeed, a major limitation of the communicator used by administrative courts is the lack of possibility to file supplement documents in the case directly at the time of the hearings. The online hearing participants must submit the relevant documents via the court office or postal operator at last 3 days before the hearing. It is also possible via electronic platform or public administration service. In the manner resulting from Article 12b procedural administrative court right, the day before the hearing. The procedural rights as a party are limited in this way, as a request for evidence made at hearing online must be proceeded by the prior submission of the request evidence to the court. Technical, in other words, technical limitation means that the file not be delivered, or the message from the to the court must be divided for 2 or more parts. So many barristers would like to send in traditional view in the paper, not by electronic, because sometimes the evidence or another documents are not delivered to the court. In addition, there is a predominance of paper case files, which also limits the possibility to evaluate them at a distance via the internet. This is not exhaust the challenges that arise in evidentiary proceedings in online public hearing as only evidence in electronic form, be it a document or video or audio recording, sent back via an electronic mailbox. The term electronic evidence includes conceptual content, which is a manifestation of human to its electronic form and which may have procedural significance. What is relevant at this point is not the medium of that information, only in a content and digital form. However, it should be noted that the medium of the digital evidence may be relevant at the stage of assessing the value of evidence. All this point is the technical possibilities available to the court to read out evidentiary information that is important. It is also important whether digital evidence has been tampered with either accidentally or intentionally, resulting in a loss of evidentiary value. Possible the falsification may be indirectly or a consequence of the medium on which the information is located, as well as due to the digital properties of the original digital information. Court records include records produced by the court or records produced in the course of administrative proceedings. They may be in electronic or paper form. As an ancillary note to this consideration, it's important to note that an important problem related to the terminological inconsistency existing in the rules of administrative court proceedings and referring to the paper and digital form or document. This terminological confusion is of great importance for the evaluation as to whether the principle of justice is implemented by an online administrative court. In the case of electronic communication, all documents should have a digital document version in accordance with Article 12b, Paragraph 3, Procedural Administrative Court Bill. And if they exist in paper form, they are to be converted to into electronic form and as a certified copy. The duplication of court records in terms of paper and electronic form is an organizational challenge, both when it comes to the court and the participants in the proceedings. In addition, the performance of evidence at a distance is related to its nature, which affects the possibility to perform such an action online. It should also be noted that is in the context of a supplementary evidence procedure, it is not so much the content of the document that may be assessed, but in the case of a paper document, the medium as such, together with the graphic elements. This is particularly relevant when, for example, minutes are drawn up by hand, considered as an official document with many elements undermining its credibility, for example, blurbs, deletion, illegible handwriting, poorly imprinted stamps. The preparation of an electronic copy, even certified copy, of such a document will not allow an effective assessment whether it has been drawn up correctly or whether its content has been properly read. Thus, a number of elements relating to the evidence procedure before the administrative court relate to the digital or traditional form of the documents in the case of file. If all relevant files are in electronic form, it's unlikely that problem will arise in online proceedings. On the other hand, in the situation of paper and electronic document is a greater risk to breach of due process, whether administrative or administrative court. At the same time, online court proceedings are more difficult where there is the parallel use of paper and electronic file. This problem for the court, for the judges, but also problem for participants. Another challenges of electronic evidence in administrative court is a new significance of documents, for example, blockchain protected or blockchain generated documents. So in some courts in the world try to use this type of protection of documents of evidence. About modification of electronic evidence, I said just, but we should remember that reading of electronic evidence, it could be sometimes a challenge because software are changing, hardware is changing too. And when the case before administrative body takes about 8-10 years, or this about after 10 years, I don't know. In first stage was 2 years, second stage 3 years. The court deleted and the case came back to the administrative body, and after next few years, case was before the administrative court. Then in this 10 years, during these 10 years, during these few times, the software and hardware to reading this electronic evidence, that court or participants couldn't have these tools. So the Polish procedure not thinking and not protect before the changing of software and hardware. Challenges behind the electronic evidential representation is huge. However, due to the small scale of the evidentiary proceedings carried out in administrative court proceedings, fortunately, they are not too frequent. But in the future, scale could rise, and we should prepare to it. Thank you very much.
Thank you very much. And now I think if anyone has any questions or anyone wants to tell something, share your thoughts, just please turn your microphone on. Feel free to speak. If not, I would like to thank you very much for today's seminar, and I guess we will see each other at November's conference. Thank you very much.
Thank you.
Thank you very much.
See you.
Bye bye.
Bye bye.
Bye. Goodbye.